So hello friends, welcome to my channel. I'm in coaching center. So today I'm going to explore that is the 11th standard business study chapter 7, that is formation of a company business. So minimum number of members to form a private company is 2, and minimum number of members to form a public company is 7, and applications of approval of the name of the company is to be made by the registration of the company, and a proposed name of company is undesirable if in case of any of the following, and a prospectus is issued by a public company, and also stage in the formation of a public company or in the following manner, that are the promotion, incorporation, capital subscription, commencement of business. Next, preliminary contracts are signed before the incorporation. Preliminary contracts are signed, and preliminary contracts are not binded on the company. So here let us know about platform. So it is necessary to get every company incorporated, whether private or public. So yes, it is true. Every company should be incorporated. And statement in a lay of prospectus can be filled by a public company going for a public issue. So no, it is false. It should not have a prospectus. Next, a private company can commence business after incorporation. So it is true, it can make the do business after the incorporation. Next, expert who help promoters in the promotion of a company are also called promoters. So no, we cannot call them as promoter because they are experts, they know correctly. So they will give the instruction, not they will promote the company. A company can ratify preliminary contracts after incorporation. So it is false, they cannot ratify preliminary contracts after the incorporation. Next, if a company is registered on the basis of the fictitious name, its incorporation is individual. So it is also false. It cannot be individual. And articles of association is the main document of a company. So it is also false. Articles of association is not the main document of a company, and every company must file articles of association. So it is also false because there is no need of every company to make the article of association, and a provision contract is signed by promoters before the incorporation of the company. So no agreement is signed or anything. If a company suffers heavy losses and its assets are not enough to pay off its liability, the balance can be recovered from the private assets of its member. No, we cannot take the money from the private assets of the company. So let us know about the formation of a company. The different stages of: first you have to need the promotion, next incorporation, and next subscription of capital. Next you have to go work or make a corporation, and next is subscription. You have to take the business what you have to do, and next commencement of business. So next fulfilling that business or doing the business. Next, let us know about the documents required for the incorporation of the company. So the memorandum of association duly stamped, signed and witnessed, and the articles of the association duly stamped and witnessed, and written and approved of the proposed directors to function as directors, and an undertaking to buy the qualification shares, and an agreement naming the proposed managing director or a manager or a full-time director, and a copy of letter obtained from the register concerned approving the company name proposed. They should be given approve, and a legal confirmation by the law stating the submission of all the documents, and the company is now registered. These are thing the need, and document evidence of payment of the registration fee. So the payment that you have to do, or the money you have to pay for registration, that should be also submitted. So these all the steps that is needed for a, or the list of documents that required for incorporation of a company or making of incorporation of a company. Next, let us know about what is prospectus and why it is necessary for every company to file a prospectus. So a prospectus is a document described or issued as a prospectus, includes any notice, circular, advertisement, or other document inviting deposits from the public. So they are the notice or the circular the company gives for the deposit from the public or inviting offers from the public for the subscription or purchase of any shares. Purchasing a person is purchasing the circular or a body corporate. In other words, we can say that it is an invitation for a public to apply for the shares or debentures of the company or to make deposits in the company. So they can the deposit means they can give the money to the company. By them they will give the shares in that company to the person. Next, a prospectus is only required by a company which wants to invite public to buy its shares or to invest in it. So that company that need only some public to buy its shares or to give invest their shares in it, they only that time it is need, not other times. Let us know about the minimum subscription. What is this? So when shares are issued to the general public, the minimum amount that must be subscribed by the public so that the company can allot shares to the applicants is termed as minimum subscription. So the minimum amount that must be subscribed by the people so that the company can allot shares to the, so the how much money they have deposit, the public has deposit, and the making of the, and the company should plan how much shares we should give, and they can allot the shares to the applicants is termed as, the shares they give is termed as minimum subscription, and the limit of the minimum subscription is 90% of the size of the issue. Next, return of the allotment. So return of allotment is the statement submitted to register which contains the names and address of shareholders and the number of share allotted to each shareholder. So the shareholders, the names or the address or the information about that shareholders that is given, that is called as the return of allotment, and it is signed by a director or secretary. Secretary is filled with the register of company with 30 days of allotment, the director said. Next, at which stage in the formation of a company does it interact with the SCBI? So a company interacts with SCBI, that is the Securities and Exchange Board of India. It do discussion or interacts with them in the third stage of the formation, that is in the stage of capital subscription, for giving subscription or taking the deposits at that time, because company is required to raise its funds from the general public through the medium of issues of shares or debenture, and to do this they need to meet the Security and Exchange Board of India, that is SCBI. They need to meet to start that to make the public to invest in that company. Next, let us know about the preliminary contracts and provisional contracts. So the contracts that are signed by the promoters of a company with the third parties during the promotion of a company are called as the preliminary contracts. That means a company is signed with a third party. If the company is signed with a third party for the promotion of their company, for making advertisement of their company, then it is called as preliminary contracts. And if the contract which are signed after incorporation but before the commencement of the business, after they become incorporation and before the commencement of start of the business, they start that, then it is called as provisional contract. The difference is here they give for third party and they already the company started, but here still it has to start and they have got the permission from incorporator or they have signed. Next, let us know about the meant by term promotion. So promotion is the first stage in the formation of a company, as you know, and it involves in the conveying a business opportunity and taking an initiative to form a company so that the practical shape can be given to exploiting the available business opportunity for the company. The promotion is important so that they may get more opportunities, and the legal position of promoters with respect to the company promoted by them or the positions is, the promoters are neither the trustees nor the agents of the company that they are forming. This is because the company does not exist a legal entity before the incorporation. They are not the promoters, the person, and they cannot make any secret profits by making deals on behalf of the company. So by if by in the behalf of promotion they cannot make any small deals, this much money will be, and they are legally liable for any untrue statement filled in the prospects of the company. So they are legally, they are only the person or legally we can say the liables for any untrue statement. They are only responsible for any untrue statement filled in the prospect or the say agreement of the company. They are only the main reason, and the promoters cannot claim the expenses incurred by them during the promotion of the company. So they cannot get any money during the promotion of the company, they cannot get, and the company may or may not identify the promoters for the payment made before its incorporation. So they cannot they will not identify any promotion if the company had given the money before the incorporation. Next, let us know about the promoters in the promotion of a company step by step. So, promoter is a person who undertakes to form a company with a reference to a given project and to set it going on, who takes the necessary steps to accomplish that purpose. And the steps they are taken is identifying of business opportunity. So the first and foremost activity of a promoter is to see the business opportunity, where they will get the opportunity to do the business or to do the money or to start the to give the a boost for that company, to give the boost for that company or to get the opportunities for that company. First they will see their next feasibility study. So all the identified business opportunity may not be feasible or profitable as a real projects. So first seeing which are the profitable for real project or which are helpful for the company, first they will see. And technical feasibility and financial feasibility are the two types. Sometimes an idea may be good but technically not possible to execute. So sometimes the idea they are made, it is very much good, it is a good idea, we can, but on the time of executing we cannot execute it correctly, we cannot execute it. And financial feasibility, every business activity requires fund, the promoters have to estimate that. So every business activity requires some much of fund, and the promoters have to estimate the fund requirement for the identified business opportunity. So the fund, they should take the project and they should make the profit for that company, so that the company will get the money for making new things, or yeah, we can say it as they are making the new ideas, for giving the new ideas for the development of the company. They will get a new ideas by the help of the money or by the giving them more opportunity, or we can say like that. Next, economic feasibility. Sometimes it so happens that a project is technically viable and financially feasible, but the chance of it beginning profitable is very little. So a company, the idea is also technically it is correct, we can execute it, financially also they have money, but there is maybe a chance of no getting profit or getting a very little profit in starting. And for that the company has to be, and so the idea will have to give up, there should be. And name approval, so the promoters have to select the name for it and submit the application of the register of the company. So the name of the company should be submitted to registered office of the company, is to be situated where in which state it is situated, and other information of the company they should be, and fixing up of signatories to the memorandum of association. So this is the promoters have to decide about the members who will be signing the memorandum of association of the proposed company. Means generally who sign the MOA become the first director of the company. So he becomes the director of the company who signs the MOA, that is the memorandum of association. And appointment of professionals, so certain professionals such as mercantile bankers, auditors, etc. are appointed by the promoters to assist them in the preparation of necessary documents. So the promoters will appoint them for making of necessary documents preparation. And preparation of necessary documents, as you know, the promoters takes up steps by to prepare certain legal documents, that includes the memorandum of association, articles of association, and many other things to make the company. So this was your question. So the what are the promoters, and what are the steps taken by promoters in the promotion of a company. So they may ask steps, that's all, or they may ask explain also. So remember that. So explain, I have explained also, and I have also said you what are all the things the promoters do. Next, let us know what is memorandum of association, and let us explain its clauses. So memorandum of association, now only we learnt they have to submit the memorandum of association. Here only we have learnt. Remove A, also we can say that A it has. So the company has to submit the memorandum of association or the signature that they are the first director of the company, as now we have learnt. So memorandum of association is the important document as it defines the objectives of the company. No company can legally undertake activities that are not contained in its memorandum. So the memorandum is the thing that contains all the objective works that the company can do, and the company cannot break that memorandum, means they cannot do any other work. Breaking the memorandum they cannot do. And the memorandum of the association contains different clauses. They are the name clauses are the clauses contains the name of the company with which the company will be known and which has already been approved, so the company will be known, and registered office clause. So this clause contains the name of the state registration office, where is their office company. And objective clause, it defines the purpose for which the company is formed, what purpose they are formed. And a company is not legally entity to undertake an activity which is beyond the objectives of the object started in this clause. So beyond this they cannot break that, they cannot do any other work leaving the work that are mentioned in that clause. Only they can do that work. If they broke that, they will be taken action on them. And the main objectives, there are different types in objectives. The main objectives for which the company is formed are listed in the subclause, and other objectives not included in the main objectives could be stated in this subclause only. They will state. And liability clause, so this clause limits the liability of the members of the amount unpaid on the shares owned by the company. And capital clause, so this clause specifies the maximum capital which the company will be authorized to raise through the issues of shares. The authority will be given full power to raise the issues. And association clause, in this clause the signatories to the memorandum of the association states their intention to be associated with a company and also give their consent to purchase qualification shares, and to purchase the shares they will do the association clause. Next, memorandum of association and article of association, let us know. So let us know about the basic let us know about the difference between the memorandum of clause and articles of clause. So memorandum, they are the directors of the company, we can say, if they have signed. Let us know about the objectives. What are the objectives of memorandum of the clause, that is also said MOA, you can say. And articles of association, AOA. So the MOA defines the characteristics of a company and the scope of its activity. And AOA defines the rules and regulations of the company. And position, it is the main document of a company which is subordinate of the Companies Act. So position, so it is the main document of a company which is subordinate of a Company Act, and it is subsidiary document of a company which is subordinate of both MOA and Company Act. That is, they both are article of association subordinate of memorandum of association and Companies Act. And relationship, so the MOA establishes the relationship between the company and the outsiders. In AOA, articles of association, they defines the relationship between the company and just with its member, not the outsiders. And alteration, so altering the MOA requires the approval of statutory authority, the higher authorities, and the AOA can be easily altered by the passing of a resolution or say giving the rules. And ratification, acts beyond memorandum of association cannot be ratified. and acts beyond the AOA can be ratified by the members. The members, if they do not violate the MOA, they can be ratified by the members. And necessity, it is necessary documents. So they should be given memorandum of association as the necessary documents, and they should articles of association should have secondary documents. So finally, let us know about the last two questions. The first last question and another question is, let us know about the effects of incorporation. Effects of certificate of incorporation and commencement of business. What are the effects? So a company becomes a legal entity with perpetual cessation on the data printed and on the certificate of incorporation, and the certificate of incorporation is a conclusive evidence of the regulation of the incorporation and legally existence of a company. Even if there is any flaw in the registration process, they will be given, and a company can immediately commence its business once a certificate of incorporation is given. They can start their business. And what are the effect of commencement of business is, the certificate of commencement of business is issued by the registration of the company when all the documents of the company is submitted. When all the documents the company gives, only that time only the commencement of business can be done, and the commencement of business certificate acts as definite proof for the company that it has legal rights, that the commencement of business gives them the legal right to do the business and to start their work. And the formation of the public company is completely once it is granted the certificate of the commencement of business. Thus the business activities of the company cannot be questioned. If they have given the commencement of business, no one can question the business, as it is legally allowed to start their business. But they cannot break the rule, or they cannot do the other work on the MOA Act, as you know. Next, finally, let us know about the last question. Is it mandatory for a public company to get its shares listed on a stock exchange? What happens if a public company going for a public issue fails to apply for a stock exchange for permission to deal its security, or fall to get such a permission? So yes, it is very much important for a public company to be listed in the stock exchange. So the public company is required to send an application to list on stock exchange to get registered. They should be send the application. Once it is listed, the company is allowed to offer its shares. In order to become public, they can offer their shares to the public people. Otherwise, they cannot offer. However, initially the company may offer only a small percent of its shares to the public, but also they will have right to do that. But if they do not apply for stock exchange, they cannot do it. If a public company going for public issues fails to apply the stock exchange for permission to deal in the securities, or fail to get such permission before the expiry of 10 weeks from the date of closure of subscription list, the allotment of shares done by the company shall become void, and all money received from the applicants will have to be returned to them within 8 days. So the company, without registering in the stock exchange, they may get only 10 weeks they will get. In that week, 10 weeks, if they do not do any registration in stock of exchange, then they will be cancelled. They will be taken the action, or they should return the money that they have taken from the public within the 8 days. They should return. They cannot give the share. They should return the money. If they have accepted the stock of exchange, they have applied and they have granted the permission, then they can give the shares. But if they have not get the permission, then they cannot give they should not give the share. They should give the money what they have taken from how much they have taken. Okay, so this was your chapter. Okay friends, this was your chapter, the formation of a company business. So okay friends, like the video, comment on my video and subscribe my channel. Coaching Center for more video. I will see you in the